We've got major implication for CRPA's lawsuit, Junior Sport Magazine versus Bonta, challenging the ban on advertisement to youth in California. This is coming from an injunction that we see out of Safari Club International v. Bonta. Let's talk about it. Hey everybody, welcome back to the channel today. With a couple of things happening in the court system, I thought it would be a good idea to revisit CRPA's lawsuit, Junior Sports Magazine versus Bonta. This was our challenge to Assembly Bill 2571, basically banning advertisement to minors in California for firearms and firearms parts. To walk us through that today, we have brought on managing attorney from Michelle and Associates. That is Tiffany Chevrant. Tiffany, thanks for being with us today.
Hey, glad to be back again.
Absolutely. Glad to have you. But guys, before we get into this today, it is working. If you want to directly contribute to litigation and legislative efforts, just like this lawsuit that we're going to be talking about today, please be sure to like, share, and subscribe to these videos. It helps get this information out there so that people can be armed with this information when they are going to decide which people are going to be representing them in the California legislature for the next legislative session. So, Tiffany, if we could just jump right in here, can you give us a brief overview of this case? You know, this was one of those cases, and that is Junior Sport Magazine versus Bonta, that's kind of had a ping-pong sort of path through the court system. Can you just remind us really quick, what is the fundamental argument here in this case, and what's been the path leading up to where we're at now for the lawsuit?
As soon as the governor passed the law, he passed it under urgency ordinance, and we filed within a couple of weeks. And we got it in as soon as we possibly could. Basically, the law said that you could not talk to anyone under the age of 18 about firearms, ammunition, or precursor parts. And what this meant is that manufacturers who were talking to kids or sponsoring kids' youth shoots, or even colleges that were trying to talk to kids about coming onto their shooting team and getting scholarships, were prohibited from talking with those kids. Our main plaintiff, Junior Sports Magazine, they were the ones that came to us and brought this case because they could no longer sell their Junior Sports Magazine into California to kids to tell them about all the stuff going on with shooting sports and competition and all of that. They were banned from that. So this is really a First Amendment issue, more so than a Second Amendment issue. And so we won at the lower courts. And then the state appealed that. We went up to the Ninth Circuit. We won at the Ninth Circuit. And then the state tried to take this en banc, just like they do every single Second Amendment case that we bring. However, the Ninth Circuit said, no, we're not going to hear that case en banc. We're going to let the panel, the three-judge panel at the Ninth Circuit, we're going to let their order stand, which meant the case now goes back to the lower courts for further review, and basically to issue an injunction was what the intent of the Ninth Circuit three-judge panel is that we would go back to the lower court and they would issue an injunction, but that obviously has not happened for several reasons.
So you have the junior sports case going back and forth between the federal district court and the Ninth Circuit. All the while, you have another lawsuit brought by Safari Club International that was essentially challenging the same thing. We have recently seen obtain an injunction from, I believe, you can correct me if I'm wrong here, from was it the Eastern District, Federal District Court? So I'm just sort of curious, you know, I mean, in a day and age where definitions are like what is a woman is kind of murky, I guess it's not too much of a surprise to see two different judges trying to interpret the Constitution and coming up with a very different response. But how is it that you get one judge in the Eastern District to issue that injunction with another judge with our case that couldn't come to that determination? And also, what does the injunction in the SCI lawsuit mean for the junior sports case?
Okay, so that's a lot of questions. So let's break it down. It's not that our judge has come to a different conclusion. It's that when our case went back down to the lower courts, to the federal court, our judge felt like she didn't have the authority for some reason to issue the injunction, which is completely outside of our understanding because the Ninth Circuit told her to basically issue the injunction. So while we've been dealing with that in our court, and going back and forth with our judge, this other case that was filed by Safari Club International, which was filed a couple of weeks after ours, that judge saw what happened in the Ninth Circuit, said, yep, they're right on target. That's probably where he was going to rule anyway. And he went ahead and issued the injunction, which is a statewide injunction at this point in time. However, in our case, we have the state actually making some really unique and new arguments around the issuing of an injunction from our judge that they've never brought up before. And through all of these hearings, all of the filings, they've never brought it up. And so now we're at a point where we're kind of going back and forth with the state going, you can't make these arguments now when the Ninth Circuit has already ruled in our favor that we're likely to succeed on the merits of the case. And so it's a big mess right now because the state has jumped in kind of playing games. And we also have a judge who's refusing to issue an injunction, but we still have to get our satisfaction in the courts, even though there's another injunction.
And I guess that can you satisfy a curiosity here, because you do have two lawsuits that have very similar arguments. They're looked at by two different judges. You know, you would think logically you get an injunction on one of those lawsuits. I don't know. Do the lawsuits either become enjoined, or what actually happens with the other lawsuit when you get the desired result from one? It sounds like what you're saying with Junior Sport Magazine is that different arguments are starting to come up. So I guess the question is, what exactly is the purpose of continuing with Junior Sport Magazine under the context of what the arguments are now?
Sure. So they don't become enjoined. It would be a merger. If both of these cases get back up to the Ninth Circuit, then there's a possibility that the Ninth Circuit would merge the cases together and hear them together. We see that a lot. We've seen that with various cases over the years where you end up with like 3 cases being heard all at once from different organizations. The reason we have 2 cases is because they were filed in 2 different jurisdictions. Maybe the cases are slightly different, even though they're still on the same law. And so what we're dealing with now is if the state is arguing that our injunction, should it be issued, only covers a certain section of the law and not the entire law, which is their argument now, out of the blue, they've come up with this. That's going to be the same argument they have in the other court. If we, in our case of Junior Sports Magazine, if we don't get some sort of satisfaction for our claims and something happens in the other court where it's not settled or it's not finalized or something happens, we have no voice in that other court. And so we can't just jump into the other court and say, wait, we don't like the way this is going for our plaintiffs or for our issues. We need you to do this. They won't do that. We have no standing there because we're not a party to that complaint. So we have to get satisfaction from our own judge. And it's really concerning that the state is all of a sudden bringing up this new argument that they're just saying that the Ninth Circuit didn't intend for this injunction to be for the whole law. It only applies to this subsection A, and it doesn't really concern subsection B. And that just can't be true because both of those subsections of the law affect marketing to youth within the state. And so there's no way that that can be true, but yet that's the claim that they're making. And so our kind of thought process is this is not the time for them to be making that argument. The time for them to be making that argument is if they don't like the injunction, the judge should issue the injunction, and then they should go fight it in trial. They should go ahead and fight for whatever issues they want. But they're wanting to try to make this injunction something that it's not, and kind of use this as leverage in a potential settlement, instead of just saying, yeah, you win. They want to fight at the settlement stage of the game, and that's just not when it should be happening. So,
Well, I can assume that these conversations will continue, at least for the time being. Assembly Bill 2571 is not being enforced by law enforcement because of the current injunction that is in place. I guess, what's the outlook that you have for Junior Sport Magazine going forward?
yeah, so I just want to say that the same issues that we're having in our court with the state challenging this Part A and Part B, which I know can get kind of confusing, but they're basically saying the whole law is not enjoined. The other case in Safari Club International is probably going to see those same arguments brought forward, because it's the state in both cases that's fighting for the right to have this law in place. So we're all going to be dealing with this at some point, but we are going to be filing a motion to enforce the mandate. Basically, it is a motion that says to the court, look, you have a mandate from the Ninth Circuit. This is not the place for the state to be bringing up this argument. You need to issue your injunction immediately based on what the Ninth Circuit said, which the Ninth Circuit opinion covered the entire law. And so we're working on getting that filed. We'll probably get that filed today or tomorrow, and then we'll see what the judge does with that. But the judge absolutely has the authority to issue an injunction. She just doesn't want to. So she's kind of playing games with it. The state's kind of playing games, and we're just having to try to force our hand wherever we can and get this done.
Well, with potential consequences of $25,000 in penalties for every single time that law is broken, this is certainly something that we're going to want to continue fighting for and paying attention to. Tiffany, I know that you're really busy these days, so I want to thank you for taking the time and coming on with us.
Yeah, anytime. I love coming on and talking about this stuff with you guys and sharing with the members. So.
Absolutely. Well, thanks again. And guys, if you like content like this and want to directly contribute to its efforts, please be sure to like, share, and subscribe to these videos. Hit that little notification bell so as these things pop up in Sacramento and in the court system, you are the first ones to know about it. Thanks, guys, and we'll see you on the next one.